Okay, folks, I think we're probably ready to get started. I know that I have a few things that aren't going to take very long, and I know I have one at least that's going to take a little bit of time. So I'm going to try to call, unless somebody is in a big hurry and needs to get out of here, I'll try to get those that are going to be quick. The first one of those I believe that I have, might be famous last words, is 16 CI 252 Endicott et al. Versus Westfield.
Good morning, Your Honor. Benjamin Harris here for Westfield. We're just looking to get a trial date, and I believe Matt McGill is here as well, and I'm sure we can work out dates for a scheduling order from that.
Yes, sir. I saw him on here, so that's why I went ahead and called that one. You all probably know all of the issues that we're facing in trying to set something. So, I'll go ahead and start looking, and then we'll see where we are.
Judge, are we gonna be looking at 2022 again?
Well, I was trying to remember. I had two cases that I got notice had been successfully mediated that were set in the fall. One of them I have already covered it up with a trial date in a different case. So I'm trying to see if I can track down the other one. Yeah, I've already done the other one too. So yeah, we're going to be talking about sometime roughly March or so. I think you had the last one, Mr. McGill, that we had this conversation in that we set first week of March.
Yes, sir.
So you're probably not going to want to set this one in the second week of March, but
probably not.
If you want to, I can accommodate you. If not, then I will. We could either look at the end of March, or we could look at probably the second full week of April.
That last week of March works for me, Judge.
Okay.
Works for me as well.
So I will only need to, Mr. Harris and Mr. McGill are the only ones that I'm needing to work with, right? To get a trial date. There isn't anybody else that's going to participate.
I've got a co-counsel judge, but he'll be fine with that date as well.
Okay. Then what I'll do is we could look at either March, or what are you thinking? Maybe 2 days?
Probably 3 to 4.
3 to 4. I could do the 29th, which 4 days would get us to April 1st, which is a Friday.
Okay. That'll work.
Okay.
That works from our end, Your Honor.
All right. So that's far enough out in advance that I don't expect you all will have any trouble with proof taking and all that, but or at least for getting a schedule for that. As Mr. McGill knows, because he just got a trial setting order for me in that other case 2 weeks ago. I usually just put some pretty broad guidelines on that, and then if people need to work out something more detailed, they either come and ask me or they work it out among themselves. And that's why, as far away as that is, I would expect you all to be able to agree. But if not, tell me, and we will look at it. I'll do a pretrial conference. I like to do that about 30 days ahead of time, or in that ballpark. So if you all are okay with February 28th.
Yes, sir.
That works for my end, Your Honor.
All right, good deal. Then that's what I'll put in there. And then if you all don't mind, just let me know. I'll get that ordered. It's not going to be today because I'll be sitting here doing this all day, and I'll be sitting here doing this all day tomorrow too. So looking at it'll be Wednesday or Thursday before you all see an order from me. So don't panic. Okay.
Thank you, Judge.
All
Thank
right.
you, Judge.
Very good. Thank you. All right. I also have, I don't think, I think we'll be able to get this one done too. Dickerson versus NAC Healthcare. That is a request to have a hearing, which we've technically, we've had a hearing. I know you all we're waiting for an order from me as a result of that hearing, and that order has taken longer than it should have, so it hadn't been done yet. So I think plaintiffs are asking for us to have a oral argument on the motion. I do not know what the defense position is.
Yes, Your Honor. Good morning, Hannah Jamison for the plaintiff. And if I could, Your Honor, I know we had a hearing back in the fall. The reason we had requested another hearing is because there's actually a new case that came out from the Kentucky Court of Appeals last month that bears directly on this issue. And so we were just hoping that the court could give us, maybe 20 or 30 minutes or so just to talk about that and how that case implicates the current matter.
Fair enough. Ms. Kreider?
Your Honor, if that is helpful to the court, the defendant has no objection. It's been 4 years since we filed our motion to compel arbitration. We've had 3 supplemental filings from the plaintiffs since your original order granting arbitration in this case. And so we're ready to go to arbitration. And if the hearing helps Your Honor, we have no objection.
All right. Well, just in light of the fact that there may have been some new law come into play since the fall when we had this conversation, I don't think, given that we can do this via remote, a Zoom hearing or something like that, I think it probably would at least be worth a shot. So I can go along with that. I don't know what you all have in mind. Looking at, for example, I would think this week it'd probably be too quick to get you all in anything, and I've got some other things going on anyway. But next week, I think I could do either Wednesday morning or Thursday morning if that would be available for either one of you. I could also do Wednesday afternoon or early Thursday afternoon. I have something a little bit later, but
Wednesday morning or Thursday afternoon would work for the plaintiff, Your Honor.
I cannot do Thursday afternoon, but I can move some things on Wednesday morning if that works. And Hannah, if you have Wednesday afternoon open, that works better for me. If not, I will clear my calendar for Wednesday morning.
I could probably make Wednesday afternoon work as well. Have to move something, but I could do it.
what time would work for you?
3 o'clock would be great.
Yeah, that's fine for me. That would be 2 to me. So I assume you were going by, I don't know. Are you in Nashville?
I am. I'm Central Time.
Yeah, so you were going 3 your time.
That's right.
Yeah, which is fine. I mean, we just need to make sure that we know what time we're talking about. But if you want me to put it down for 3 o'clock, I can sure do that.
That'll work, Your Honor.
All right. We'll get something out. That won't be too much trouble. We'll just get a quick order out to set that, and I'll get the link set up and send that to you. But it's the same every time, so it's the same link. So if you just click on the link that you clicked on for the previous hearing, and there's anything going on, that'll be what's going on. Okay.
All right. Thank you, Your Honor.
All right. Thank you. All right. Crystal, you got that for me? All right, folks, let's look at Psycho Land Holdings versus Benton.
My motion, Your Honor, to dismiss. However, some of the defendants also have claims. We have no objection to the order that was tendered regarding letting their claims carry on while Psycho is dismissed.
Okay,
Good morning, Your Honor. Clyde Combs for the cross claim at Hazel. We had filed a response and tendered a proposed order that basically said their claims are dismissed, Psycho's, but all the other cross claimants' claims will continue. And we tendered that electronically on December 15th with our response.
yes, sir. I was looking for it because other things have been filed on top of it, but I've tracked it down. And it should probably also be in my electronic document queue, but in the event that it's not, I wanted to get the hard copy, so it's right here. And if nobody objects to the entry of that order, that looks like it's probably adequate to cover everything that we need to do and keep the things that need to stay on.
Thank you,
Your
Your
Honor.
Honor.
Your Honor, George Fletcher for one of the cross claimants too, and I agree with Mr. Combs, so
Okay,
the order's fine.
all right, then I'll get that entered probably today. It'll just be, if it's in my electronic documents, it'll be easy. If I have to scan it in and all that, then it might be tomorrow before I get it. But we'll take care of it.
Thank you, Your Honor.
All right, thank you.
Thank you.
I'll just check on that when I get done with this docket here. Jefferson Capital Systems versus Hunter.
Good morning, Your Honor. Courtney Carr for the plaintiff.
Okay. I don't,
Can you hear me okay?
I can hear you.
Okay. That is our motion for default. We just need to withdraw the motion. We're working on settlement.
Oh, okay. I can live with
Yeah.
that. I can live with that. All
Okay.
right. So, that's 20 CI 492, and I will just make a note here that at the plaintiff's request, the motion is withdrawn.
Okay. Thank you so much, Judge. That's all I have.
All right, thank you.
Thank you.
Yeah, I'll just write it right here. Green versus Summers Exchange.
Yes, Your Honor, this is Joe Griffith for the plaintiff.
Lee
Yes.
Sittlinger, Your Honor. Lee Sittlinger, Your Honor, for defendant Walgreens.
Okay. I believe this is Mr. Griffith's motion for him and his firm to withdraw. He indicates in the motion that this is with the consent of plaintiff, Ms. Green. Plaintiff was given notice of the motion by certification on the motion. So I don't suppose Ms. Green is on here. Mr. Griffin, am I getting any part of that wrong?
No, I can give you a little more detail about what's going on, Your Honor, if you'd like.
Okay,
So this is a trip and fall case in a Walgreens parking lot. I had talked with Lee about a resolution, which the client, I believe, was on board with. Lee sent me a check and a release. The client evidently talked to another lawyer and got the idea that the potential resolution is not satisfactory. And she decided to discharge myself, and therefore I filed the motion.
okay. Well, this is not the first time I've heard of that sort of thing happening. It's unfortunate when it does, but
It's on here, so I'll pull it up and we'll do it.
I do not certainly have any issue at all with permitting you to withdraw.
Your Honor, this Lee Sittlinger, I spoke with Joe
It's coming through.
this morning, and I had filed an objection, and my only objection, I guess, is more of a frustration thing. When this type of thing happens, these cases just seem to hang on forever and ever and ever, and dealing with the client without counsel and whatever.
Let me interrupt you for a minute. Let me interrupt you for a minute. Folks, if you're on this call and you're not talking to me, put yourself on mute, because I'm hearing a whole bunch of conversations that I don't need to be hearing. All right. My apologies. Go ahead, please.
No, and the only thing I told Joe is that we'll be filing, I guess, a motion to enforce the settlement, and Joe has an address. We had propounded several months ago interrogatories which were never answered, so I don't have any information about this lady's address on his motion. Joe has an address, and I can send the copy of the motion to that, but I'd prefer that Joe be at least, instructed to provide her with a copy of my motion, because I don't want to get in a situation where down the road she says, well, I never got it and all this, because I'm dealing with a pro se client. So, well,
let me ask you this. His tendered order provides her 30 days to have counsel enter an appearance on her behalf. It sounds like to me, if she has already, it might have been one of the old, I spoke to an attorney and he tells me that this case is worth 10 times as much, but he's just too darn busy to take this case. And, which obviously, when those things happen, usually the advice is not worth anything. What I was wondering is if he's given her address on his motion and on his proposed order, and if nobody files an entry of appearance within 30 days, she'll be non-compliant with that order. Would that be too long for you to wait to file your motion to enforce what you believe the settlement agreement is?
No, Lord willing, I'll still be around.
We all have our, fingers crossed.
But Judge, I guess the only other thing is there was and Joe can speak to this more than I can. There was there's another defendant who is the landlord, and basically they really don't even belong in the case, and I don't know where Joe and the attorney for that company was, whether Joe agrees that they should or should not be in, but there was, in any event, there was I understand to be an agreement between Joe and the attorney. His name is Mike Casey, for an indefinite extension to file an answer until they could work that out. The reason I'm bringing this up is because without Joe in the case, my client basically has an obligation to defend that client. So we'll be filing an answer on that landlord's behalf, because it'd be my concern that without Joe in the case, that agreement for an extension may or may not apply anymore. So I guess I just want guidance. Should I go ahead and file an answer for that landlord? And
that defendant has filed an answer already.
Oh, okay.
If you're referring to Summers Exchange 3 LLC, it filed an answer on 12/1.
Oh, okay.
Yeah.
Well then, sorry to take up your time on all that.
Oh, no, that's fine. But I think that probably covers, what your concern was. Because
right, I'll probably just file a motion to be substituted as counsel, but I'll wait until we see if she gets an attorney involved. So,
and if I don't have a problem shortening that 30 days to 21 days, and I want it to be a legitimate opportunity to have an attorney enter an appearance, but it sounds like to me that she has spoken to an attorney, and for whatever reason, if she's going to go forward, I would assume thinks she's going to go forward with that attorney. So I don't have a problem with shortening that 30 days, by a slight amount or whatever, if it would just go ahead and help this thing get moved along in whatever way it's going to. But I feel like if you're protected by filing your motion if nobody enters an appearance in compliance with this order and use the address that her counsel, now former counsel, gave as her address, which he should know what it is. So I believe he's going to be accurate at the time that it was given. And, it's her obligation, just like any litigant that's representing himself or herself, to, if their address changes during the course of the proceedings or whatever, to notify the appropriate individuals. So, if you could wait 3 weeks, I'll enter that order and shorten that period of time to 3 weeks for her to enter an appearance, have an attorney enter an appearance, and then we'll move on.
That'd be great.
Either way.
That's great. I appreciate it.
Okay.
I appreciate it, Judge.
No problem. Does that cover everything that's on the agenda in this case today?
I believe,
Yes, it does, Your Honor.
so.
All right. Thank you very much. Well,
Thank you, Judge.
I believe, I can change that just on the electronic order. We can overwrite in small increments. So I'll just change that. Okay.
Thank you, Your Honor.
All right. Thanks, Judge.
Bye-bye.
Take care. Bye.
Thank you. Let's see here. I don't think anything else is going to be very short, so I suppose let's get them in chronological order at this point. Overfelt versus Shogun of Japan et al.
Honor, Luke Wingfield here for Shogun of Japan.
Yes, sir.
Morning, Your Honor. Brian Louder on behalf of plaintiffs.
David Barnes on behalf of auto owners, Your Honor.
Okay.
Judge, one of our motions was a motion to compel, and I've talked to Mr. Barnes. We've got an agreed order that'll be submitted on that, so we've resolved that issue.
Fair enough. That leaves us with the deposition issue, right?
Yes, sir.
All right. Of course, I've read your motion and I've read Mr. Wingfield's response. If I don't believe that I have seen another response. Let me look in here and see. So that being said, I have not gone and done any of the research that we would need to do. It seems like there's probably only going to be federal cases that get into this. So you all know what goes into looking at those and, trying to make sure that the rule they're interpreting is the same as the rule that we are supposed to be following, and then kind of going from there. So I feel like maybe I need to do that if this remains a controversy, but if there's anything either one of you want to say in support or opposition to the motion that's in addition to what you've already filed, that's fine, but I'm already familiar with your all's arguments.
I don't think we have anything to add, Your Honor, unless the court has any specific questions.
I don't really.
And Your Honor, Luke Wingfield, I just point out that our response is, even though it's lengthy, it's real simple. I provided the stack of emails with the court reporter, so the writing's required. And we believe the rule allows us to amend as we have done without any, there's no prohibitions at all. And I think we followed the rule properly here as outlined in our response. It's not a very complicated thing to us, and I believe it should be summarily overruled.
Sure. Okay. You all just kind of bear with me and let me look at it. And like I said, pull up those federal cases and take a look at those. But I think I have a pretty good handle on what's going on. Okay.
Thank you, Judge.
All right. Thank you. Let's just hold that. Rogers versus NHC. Is there anyone here to make arguments in that case? You know, Miss Kreider was here. I wonder if she just kind of forgot that she had this one. Well, I tell you what, let's kind of hold off on that, and when we get together on that other hearing next week, I'll ask her what she intends with that, because there's no response or anything that I located. So anyway, we'll move on. Gossett versus Hester.
Brian Pack.
Judge, I'm here. I believe it might be my motion for Miss Hester for a trial date. And a
I believe
status
so.
conference.
Is that what you think we're doing here?
It is, Your Honor.
All right.
We've kind of been
something-
going through. Sorry, Mr. Pack, go ahead. I didn't mean to interrupt you.
Oh, that's okay. This is, it's a Declaration of Rights Act case that I filed to resolve a will interpretation. There's been counterclaims filed that have raised other issues regarding the settlement of an estate. So, Judge, I guess the one thing you may need to look at is to what extent there may or may not be a jury issue. Going back to law school, if I remember correctly, when it's simply the interpretation of a contract or will, you first have to determine whether it's ambiguous or not. If it's not, then no parole evidence comes in, which obviously shortens a trial significantly. If you believe it's ambiguous, then parole evidence does come in on the interpretation. So it may be that you might want us to brief that issue, or you may be able to read the will itself, because it all goes to whether a particular bank account is encompassed within the wording of the will or not. That's going to decide a big, huge part of this case. There are other issues raised, but whether a particular, we call it a business account, is part of the business that was awarded to 2 of the 4 siblings, or whether it goes to the residuary clause of the 4. The other issues, I think, might be issues of equity anyway, so I don't know that you get a jury on that either. So I wonder if there may be some benefit in us having a schedule where we submit, we can pick a day, there's no problem with that. It's just a question of what's going to be done on that day, if anything.
Right. Yeah, the issue normally comes up in the context of, somebody either filing a summary judgment motion or some other sort of dispositive motion, and then, you decide whether there's an issue where the case needs to stay on the docket or not. I guess it doesn't really matter which direction you approach the question from, whether you approach it from do they deserve a jury trial under the rules, or do they deserve it to be dismissed under the rules, that kind of thing. So I don't really care how we approach it, but it does sound like it might be a good idea to, find out what it is that we're going to be needing to argue about, and what kind of proceeding we're going to need to be having before we actually schedule the ultimate proceeding, whatever it ends up being.
Can I say something for the record, Your Honor?
Yes.
We have breach of fiduciary duty claims, I think is the main claims that we've made, the counterclaim here. And to that end, we've been trying to get depositions scheduled for Mr. Ricky and Dennis Gossett, and have not really received those, or an accounting or an inspection. So we're trying to keep the case moving. That's what we're trying to do. And I thought a trial date would give everybody something to work towards. And because this is one that needs to keep moving, just to be quite frank. So
I agree with Mr. Burley's statement. Something that federal courts do, Your Honor, I think is very helpful. They actually set a dispositive motion deadline. And I think that might be good for us, kind of give us, you've got to file your summary judgment motions by a certain date. And then, they have a trial date out there as well. And also, Mr. Broderick in earlier conversations had suggested mediation, and I think that is well taken. And the court may want to order mediation as well as part of this.
Well, yeah, I mean, thank you. It's always at least strongly suggested when you have family or, closely held relationship type of issues, which is what generally, but not always, are implicated in a will and estate problem. So, yeah. Well, I tell you what, the reason I'm saying it the way I'm saying it is because it's a whole different ballgame. You all probably were listening, our jury trial days are, it's not going to be real likely to get a jury trial day, quite frankly, for about a year. We're now on over a year or right at a year of not having had any jury trials, the vast majority of which weren't settled. They were just shoved off to a later time. So, if I was 9 months out getting a jury trial in March, I'm now 12 plus 9 months having any jury trial dates available, which, if my math is correct, is 21 months. So that's an exaggeration, but not by much. A bench trial is a whole different animal, because you can do a 3-day jury trial in 1 day if it's a bench trial, that kind of thing. So, those are not going to be hard to come by, but, and I don't know that I want to set a date for you all that's in April of 2022 if I don't have to, So it seems like to me, maybe it's getting to the question of whether we're going to need to do that, at least on all these other claims pertaining to the meaning of the will, if I understand what you're saying, or how extensive, whether an asset fits within one clause or another and that sort of thing. But listen, you all, to a very large degree, kind of steer the way that the thing moves. So if you want me, Mr. Murley, to set a jury trial date, then that's what I will do. And then I'll schedule a time not too far off in the future for everybody to file whatever motions that they want to file regarding that and regarding either partially or fully dispositive motions. And we'll handle it that way. That's up to you.
And I guess before that date, we would need a chance to take some haven't been trying to get dates, just haven't been able to get dates for these individuals, which would drive some of the dispositive motions.
Well, I guess I can help you with that too, if it gets to that point, but surely it won't.
Your Honor, I think we could do those depositions the first week of March with our last day, or I've got February 25th, March 2nd, 3rd, and 4th. So that whole week available for depositions. So I think if we set a dispositive motion deadline of maybe April 1 or May 1, whatever Mr. Murley thinks is appropriate.
April 1 would be fine. Do you want to build in a mediation deadline, or that's something we discussed? I don't know if you think that would be helpful.
I suspect Mr. Broderick will want to take the depositions first, or you, before we do the mediation.
I would say so too.
Guess.
Yep.
And it's sometimes helpful to see what the dispositive motions say. So that usually motivates people to settle when they hear the other side in writing. So maybe a June 1 deadline for mediation.
That's fine with me. Like I said, I'm kind of letting you all.
Well, if we won't get a trial date for 12 months, then at least we can get some stuff moving towards something. So
yeah, sure.
Yeah. So, okay.
Yeah. We're looking at, I just set last week a trial on March 1st through 4th. And then just now I set a trial on March 29th through April 1st. So there will be 3 weeks in the middle of those two that I would be available. And that's the first thing of more than a day or two in a row that we would have.
For 2022 is what you're saying?
Yes.
Okay.
Are we in fact setting June 1st as the mediation deadline?
Well, if everybody can agree on this trial date, on a trial date, which I haven't put a precise date on there yet, then I'll work backwards from that, and we'll set some, I'll set a mediation deadline, which if you all think June 1st is fine, you all know more about it than I do in terms of where you are and what you know. So if everybody agrees to that day, then I'll be more than happy to implement that into something.
I think we're fine with that day if that's what we have to get. And just in case it doesn't resolve. So
yeah,
I'm fine with that day.
And then a motion, you could, I guess we could do a motion deadline, I mean, it wouldn't have to be April if it could be May since. Are you wanting to have the hearing on the motions before you have a mediation?
No.
Yeah, okay. Then the deadline could be May, like May 1st or thereabouts, and then June 1st on the mediation. Because, I mean, everybody will be getting ready to file their motions, and that would kind of serve double as a preparation for your mediation and all that anyway. All right.
Right. And I don't know if you gave us a date for the actual trial. You said the second week of March or something?
Yeah, well, I said we could do the second, or, I mean, I have a trial the first week and the 5th week, so it could be anywhere in between there. Second, third week.
We're wide open any of those times.
Yeah.
So,
I guess I'd prefer to do the second week. Just,
okay.
Pick a day, Your Honor.
that's the quickest. All right. Well, would 3 days cover it if we got
Yeah.
Gosh, I
It would
hope.
cover it.
9, 10, 11?
That's fine.
That works, Your Honor.
But I'm in line with Mr. Broderick's client, who I represent, letting them do all the talking here.
All right. Hampton is crafty enough at this stage to know that if you don't have anything to say, it's just best not to say it. But if it's doing all the talking and they're adequately covering it, then super. All right. So
I think that covers everything for us, Your Honor.
yeah, let's do that. And I wonder if you were writing those dates down. Do I need to go down those with everybody? All right, fair enough. And then
I think we'll follow up on the depositions and on the accounting that we're waiting for. So
gotcha. Let's
right.
set a pretrial conference. Just go ahead and set one for February the 7th of 2022. And of course that we can always move that if we need to.
At a certain time, 9?
9.
Okay. Okay, thank you, Your Honor.
All right, thank you. All right, folks, that gets us down, I believe. Do you have 2 files or 1? Is anybody here on Williams versus Patrick? Is that you, Mr. Pack?
Yes, that's my motion, Your Honor, for default judgment. I've not received any response other than one time Mr. Patrick called my office and left a voicemail saying, call him, which I did, and did not reach him and have not heard from him since.
Okay. Roughly 2 weeks ago, I sent a notice to his last known address with all the Zoom information on it in the event that he was interested in participating or opposing the motion. And I do not see anybody on here that I don't already recognize from prior activity in other cases. So I would guess that none of you all are him, and therefore I will grant Mr. Pack that motion. Okay?
Thank you, Your Honor.
Thank you. Estate of Bush versus virtually innumerable others.
By the way, I apologize. I think I'm the one who was not muted a while ago, and I thought I was, so excuse me.
That's all right. I had so many people on here, I didn't want to go down through there and try to look at everybody and see who was muted and who wasn't, so
Pretty sure it was I.
Yeah. All right, well, no harm, no foul. All right, we got a lot on our plate here. Essentially, I think it all starts with Mr. Davis's motion and then the various motions that I actually can't really tell whether his motion.
My limited motion.
I can't tell which one was filed first because they were both put in the file on the same day.
Response and objection.
But
I don't see.
Do what?
Thought I was muted. I didn't see Ashley Garrity.
Oh, okay. All right. So Mr. Davis, go ahead and state your motion, and then we'll let everybody just go down through there. And
Your Honor, I filed a motion with multiple parts, first of which was to sell the farm and all personal property of the estate. The estate has equipment, personal property. There's personal property in the home. German American has filed a motion for summary judgment on their foreclosure action with regard to this farm. If the farm were sold prior to the sale of the personal property, the estate will have no place for the equipment. We'll have to rent a place to store it, for which we do not have funds. It makes sense. It's just logical to sell it all at one time at the situs of the farm. I think it will generate the best response from the public, and all the parties will get the benefit of the best sale.
it seems like there are some the opposition to your motion comes in a couple of different forms, and one of them is the format of the sale. You know, like each individual lien holder or mortgage holder wants a judgment in its favor and to proceed with a sale like you normally would in any other case. But this is not any other case. It also seems like there is an opposition to that aspect of your motion, and I believe that was also in the partial report from the Master Commissioner about the distribution of the funds. And I'm not sure which one is the more pressing objection. Do you both object to Mr. Davis's proposal about the sale and object to the idea that the money needs to be held until there can be a plan to distribute it? Or do you really just object to the money part more so than the format of the sale? I guess that's what I'm trying to figure out, because that'll help me. You know, I understand your position on the distribution of the funds, which is we're secured creditors, and the money that our client is supposed to get is supposed to go to our client without reference to any other expenses or any other things that the estate might owe, because that's one of the benefits of having that security, right? And so I think that's the fundamental argument in favor of not holding the money and getting some kind of global distribution order. And I understand your response, but I want to start with finding out whether there's any way to come up with an agreed way to sell all of this rather than do it in piecemeal. Master Commissioner say.
On behalf of German American Bank, we submitted a very detailed proposed judgment and order of sale in regards to the farm and the home. It has all the terms of the auction contract, and we tried to incorporate specific issues that Tom had raised in regards to he wanted the property surveyed and tracked. So we've included a provision for the auctioneer to do that. We've requested that the auctioneer he had previously talked to be retained. We've also requested that there be funds to clean out the house be set aside. So I think what we've proposed is a very detailed order of sale, whereas he's just asked that the property be sold, and it doesn't include any of the terms. And on behalf of German American, they want to have the ability to credit bid. And they also like to include that, that if they have to bid the property back in, if they're the purchaser, then the auctioneer only gets 2%. Well, that's incentive for the auctioneer to sell it for more than what German American is owed, and therefore it benefits everybody. So I feel like the order that I've proposed is in everybody's best interest and is very detailed and encompasses all of the terms of the sale. So in regards to that, I do feel like that's the issue.
Okay, yeah. So your beef is mainly not that there is a coordinated way to sell it, but that once the sale occurs and the money comes in, it ought to be immediate to the various lien holders that are represented in the property that was sold.
Well, I think it's both. I think we need the terms that I've included in my judgment in regards to the way it's going to be sold. And then I also believe that the distribution should occur immediately.
Okay. Let's see, Mr. Davis.
One of the underlying issues that could affect the proration of cost has to do with regard to whether the state is solvent or insolvent. That was the underlying premise for withholding distribution for a short period of time until all of the assets were liquidated. It will be difficult to determine absolutely if the state is insolvent because one cannot predict with accuracy how much the farm is going to sell for example, at Dry Fork Road. Although it does appear that the estate is insolvent when you look at all of the claims, both secured and unsecured. Some of the unsecured claims, some of the secured claims, for example, will become partially unsecured based on my observation of assets. For example, the rental property, some of it has secured debt that exceeds what appears to me to be fair market value. But I agree with Ms. Garrity that her sale in terms of what she's proposing is acceptable. I didn't go into detail, but she has adopted many of the things that I requested in the initial complaint with regard to the sale of the farm. That is survey tracts, adopting the best sale, and Hunt does sales engaged in that type of combination of tracts and so forth. I was seeking to get the best sale for everyone was my goal, and I remain on that track.
So in terms of her proposed order, at least, it doesn't really deviate from what you wanted. It's got a bunch of more specific detail in it, but you don't object to those details in terms of how the sale would be conducted.
No, sir, I don't. Now, there is one underlying issue that was raised at some point, and that it's a master commissioner's sale, and the judgment provides for a buyer's premium. Ms. Berry may be able to address that, but I have some question back in my mind whether a master commissioner sale can require a buyer premium. If it can, it's fine with me. I'm not hung up about it.
We've done that in numerous jurisdictions and not had an issue. So I don't anticipate that being a problem. I'm unaware of any restriction in regards to that. So long as the auctioneer's fee is capped at 6%. If the auctioneer cannot get a higher commission than 6%, is my understanding of the law.
What's Ms. Berry think?
That was my concern, was that there be a limitation on the amount of the commission. I have not been experienced enough in terms of standards in the industry, and I know this add-on commission is something that has only developed in the last few years. As a matter of fact, in this area, it's been extremely rare. There have been some sales to that effect or handled in that manner, but it is not the standard by which most people bid locally. Yeah. I don't have anything to support that. I don't have any statistics. I just have a preference. And I can think
of only one case where this issue came up, similar issue came up, and then it ended up being obviated because a bankruptcy got filed. So it kind of, the property never got sold in the first place. Mm-hmm. So you never get into the amount of,
This was at the auctioneer's request, is why it was added, because he felt like this was standard for this type of sale. And so I feel like it might be difficult to find an auctioneer willing to participate if we don't allow that buyer's premium, but still cap him at his statutory 6% commission.
I got you.
Your Honor, I'm just going to throw in here because they absolutely will not allow that anymore in Warren County, E-Town, any place based on the wording of the statute that allows a mortgage company only, the mortgage company, to request the sale, and then it's to be a commission. It's not to exceed 6%. Now, that's what I think it is, just so nobody runs afoul of anything. And Mr. Broderick has told me the AOC was on him over that, where one of the local auction companies tried to do it, and he had to change it at the last minute.
So
I mean, I don't think it's a big deal. They don't care if they get paid 6% one way or the other. I'm just telling you, in these jurisdictions around here that dealt with it, that is what I've seen in the last year.
So your point is that
6%'s okay.
Yeah.
What Ashley's doing with, 2% only if they're not agreeable. Pretty much I've had any number of auction companies take that because they want the sale, and I've never seen a bank pay the 2% and try to keep the property.
Yeah. So you're endorsing her proposal.
I'm endorsing exactly what she's doing. I'm just telling you it involved a top dollar auction recently with Broderick trying to do that, and it would cause trouble here. E-Town, it's caused trouble. I don't have the statute in front of me, and Ashley can take a look at it, but I'm just letting you know other jurisdictions, and Broderick has blamed the administrative office of the court on not being able to do that.
Okay. Well, I don't want to spin our wheels and do, however long, a month or 3 weeks worth of prep and all that and get up there to the sale date and have a problem. So.
Avoidance of problems then would seem to be standard that we've used.
Do what now?
To avoid any of those problems, it would seem to be to use the standard that we've been accustomed to.
So are you requesting that we remove?
Feedback, excuse me.
Just so I understand, are you requesting that we remove the buyer's premium and just provide for a 6% commission? Is that basically the issue, Tom and Cheryl?
I think that removes a lot of risk. The ultimate risk is that you go through the sale and then have someone file objections for approval of the master commissioner sale because it required a buyer's premium. And boom, it creates a lot of chaos. I think if it provides a 6%, given the nature of the property and so forth, the auctioneer should get paid.
Right. I think it's just their advertising issue. There was some concern because they traditionally advertise with a buyer's premium, and then to advertise separately, there was some questions there. But I do feel like if that's the only issue, I feel like that's something we can resolve with Jeff. I don't anticipate the Hunt Auctioneers is going to, not be willing to participate. But so I think if we could have an opportunity to discuss that with him and tender a revised judgment, I don't foresee that being a problem.
Okay. So how would you like me to proceed? I'm rapidly running out of time because I've got about 5 or 6 jails that are trying to join in here for my 10 o'clock docket. We've got inmates spread all over the Kentucky, and I can't really keep them waiting. So tell me how you want me to proceed. If we're all the way down to that one kind of sticking point, do you want me to put this maybe back on for Monday, and if you tender an agreed judgment before then, or a judgment that you've circulated and then you just represent to me, it meets with everybody's approval, then I'll sign it?
I just received a message from Jeff Harnett. He's actually on the line, and he said we can remove the buyer's premium. So if I can tender a judgment with all the details that I currently have, with the distributions being made to German American, all of that, then I'll remove the buyer's premium, and that should resolve all the issues. Correct?
Okay.
Can we add a commission for the sale of the personal property so there's no question about that as well?
I cannot. I don't have any interest in the personal property. German American has no lien on the personal property.
I understand, but I'd like to have the order of sale to provide for the sale of the personal property, and it would help if we had a commitment from Hunt that they will sell it and what they're going to charge in way of a commission.
I agree. I just think that has to be a separate order. I don't think I can do that. I think we could piggyback them together. I'll file my order, and then you file one that says it's also going to be sold inconsistent with the order on the same day as the order entered by German American. I'm not to be picky. I just don't feel like I have any ability to do that.
Yeah. I mean, that's kind of straying out of your outside of your marching orders.
Right.
Yeah.
Well, I have one question regarding the procedures that we're going to be going through, and that is, with the numbers of tracts that are being sold and the locations of them being various and sundry, how many days is this auction going to take?
It'll be one day on site and online. And the way that Jeff will do it is he'll offer it in pieces, and then he'll offer it as a whole, and he'll take the best number, basically.
Will it be just one site, or will they move from one site to the next?
Hey, Jeff, could you unmute yourself maybe if you're still on and tell us some details about what you propose? Hate to put you on the spot.
Yeah, you're muted, Jeff.
Sorry.
That's good.
Everybody. Okay.
Thanks, Jeff.
No problem. So we're talking about the farm and the house. So no, there will be no reason to move around. We will have visual displays at the sale site for to show what tract we're selling at what time. But what we'll do, we'll sell tracts individually and then in any combination, including the entirety, and then with pullout. In other words, if somebody puts the farm together, but there is a party interested in a combination of tracts, they can fracture the whole. We adopt the highest total all the way through the sale. That's how you get the most money for a property, because you don't exclude anybody from the bidding process just because they're not interested in the whole.
But are we not talking about selling all of the real estate, even not just German Americans real estate, but these other folks real estate too?
No, Your Honor, I'm only talking about what German American has a lien on, which is the farm and the house. That's all my judgment covers.
All right, fair enough.
Well, we've got the attorney for several other portions of the property.
I'm here, Your Honor, for Monticello Banking Company and for Franklin Bank and Trust Company. And their properties, I mean, one is a house that's got the floors torn out of it. It's probably not worth $25,000 now. That's separate. We just want Cheryl to sell it. Same way with Franklin Bank, a number of properties with trouble. The only real, I think, sticking point in that was, you know, the bank's kind of, there is a dispute be resolved by the court as to who gets paid first, a secured creditor or administrative expenses and the legal fees and so forth of the estate. So we added language, not just in German American's bank that's going to be revised apparently and hopefully signed, but in the judgments I tendered, and it says after Cheryl's paid, the cost of sale adds that, appraisers, that sort of thing. The next thing that'll be held, I'll just read it. 3% of the gross proceeds from the sale of the real property that is the subject of this action should be held by the Master Commissioner of the Barron Circuit Court pending further orders of the court. This amount is being held until disputes can be determined by the court as to the plaintiff estate's rights to reimbursement of prorated court costs, service charges, filing fees, and the estate's claims that its attorney's fees have priority over the bank's secured mortgage claims. It is agreed that this 3% amount of the gross sale proceeds and the distribution thereof is a disputed matter to be determined by the court at a later date. And we've put that in everything, you know, then ultimately before that 3% and that fight takes place, Tom can get his wish and everything will be sold.
Okay. Thank Mr. Davis.
I think that's constructive approach, Your Honor.
Yeah.
And Ms. Garrity, I think it put the 3% holdback in her proposed judgment. That's consistent, and I think that's a constructive way to address this by the court.
Yes, Your Honor, we are in agreement with the 3%, and I will make sure that is included in the revised judgment that I tender.
Okay. All right. So is there anyone else that's wanting to chime in here before we?
Your Honor, Darren Mexick here for South Central Bank. I just wanted to be clear. It looks like Mr. Davis's order, he is not attempting to sell the two properties that are now in the name of Yvonne Cook by right of survivorship. I've gone through the order, and that's what I just want clarification on that. Is that correct, Mr. Davis?
Yes, sir. She's already entered an appearance, and I think there was an order entered in that regard where the debt is solely hers and the property is solely hers by virtue of the survivorship.
Okay, great. I haven't seen that because I'm fairly new in the case, but I've been dealing with her counsel. I expect South Central Bank's claims to on those two notes to be paid off once that property is refinanced by Ms. Cook. So
I can't believe you haven't seen. I mean, there's only 5,000 pieces of paper in this file.
It was just a 55-page order with 40 pages of legal description. I tried to go through it as best I could, but
yeah,
Your Honor, Ian Lose here for your Von Cook. I don't know that order's been entered. I know I've been working with Darren Mexick and his predecessor counsel to get an agreed order. I do expect an agreed order to be tendered within the next day or two about those two properties from Ms. Cook.
Well, even if there hasn't been an agreed order, Mr. Davis is not seeking, in his proposal, he's not seeking a sale of that property.
That's correct.
Anyway, so I guess if he tried to seek it later, despite what he's saying here on the record, you all could bring that to my attention.
Can we?
It's already been addressed with her being a survivorship.
Your Honor, Your Honor, Austin Green with the Department of Revenue, and I just wanted to make sure with where we're proceeding that you are going to be entering German American Bank's order. You're not going to be entering the order from Mr. Davis directing the sale of the farm personal property. You're going to be entering the one from German American Bank.
I am, and I think somebody is going to tender a replacement for Mr. Davis's order, probably Mr. Davis, that allows that farm property, equipment, et cetera, to be sold under the same terms as the property sold in the German American Bank order.
Right.
But it says that.
The only thing that I wanted to go on the record with that was of any concern is in the one that was tendered, he was asking that the order affirm his exceptions to the limited report and his proposed findings of fact. And with most of the exceptions and proposed findings of fact in there, I don't have any issue. It's just number 6 that he has in there with regards to the Department of Revenue. He has it laid out that the payment of the claim is purely a Glenview healthcare facility issue, and since we have not received the full report from the commissioner, we just don't believe that any order should be entered that would enter paragraph 6 of his executor exceptions to the limited report.
Okay. And certainly we have not really talked much about the objections. If we're going to do that, we'll have to probably.
And I just wanted to put that on the record because it was in the order that he had tendered.
Understand. You see what he's saying, Mr. Davis, I guess?
I think so. I'd have to go back and look at number 6, and certainly I will do that. I'm not sure that number 6 is dispositive, but I will look at that in terms of that order, and I will also be in touch with the auctioneer with regard to the personal property and try to incorporate that with regard to the proposed order as well.
Yeah, when you change your proposed order, or when you change the order and get ready to retender it, it might be a good idea to kind of swing it around the table like we have done at other times to make sure that, because there are a lot of moving parts here, and we want to make sure that we're not, nobody's fingertips are getting cut off, you know.
It's my impression that order was circulated at the time I did file electronically, and it was my intention that everyone have the benefit of it prior to today's hearing. There's one other, of course, I've got proposed findings of fact and conclusions of law. And the reason I did that was to supplement the Master Commissioner's report, because there's a number of parties that are before the court that did not comply with your order in terms of appearing at the creditor's hearing. And what I was attempting to do was, for lack of a better word, scrape off a number of parties in order to simplify and reduce this in terms of what the debts are and so forth.
Right. I anticipated that that would probably happen once people realized that if they were an unsecured creditor, for example, they might be holding the bag metaphorically.
Well, a number of them conclude they don't want to spend the money to employ an attorney to chase the relatively small amount that's owed to them, so they write it off. And some of them even sent me a letter and waived it, and I entered an order, proposed order dismissing those people. So yes, but it's just a matter of trying to simplify this and get it to where we can conclude the litigation.
Understand. Well, I will. Miss Garrity is going to make that's one fairly simple change, right? And submit submit that proposed judgment to me. Mr. Davis is going to submit a different proposed judgment regarding the personal property that I think he's going to talk to maybe to Mr. Harned before he does that. But it sounds like that'll be coming in the due course of business. And I don't know that I'm expecting any other orders right now. Tell me if I am. And then
you are expecting one from me. Mr. Davis and I talked about this 3% holdback late Friday. So the two orders that you'll be signing for Franklin and Monticello that contain this, we will email those right after this hearing to you. Okay. And I don't think there's an objection. This is exactly what you said, do sell them and stop the interest.
Gotcha.
And we're going to do the holdback.
What I was trying to make sure is that I didn't accidentally sign an order that was already in there thinking, because they're all in my electronic queue, and I didn't want to sign one when I'm waiting on another one. But now that you've told me that, I remember having that conversation. I'll make sure I don't sign the one that's already in there.
And I have two other just housekeeping matters. Number one, there's a truck that Carlotta Bush was using, and sometimes they'd use it in connection with the Glendale. No one's using that truck now. Rather than having a hearing, I'd like to submit an agreed order with Tom, just to take that to our people take it to the Glasgow auto auction, sell it, use the same holdback type, but just strip the liens under Article 9 and not have to have a hearing to set that, since we've already got many people answering. The other thing I would like to do is there is a Bush Jones property that's a rental property where the estate owns half of the LLC units. A bank I represent holds those holds the mortgage on that, and we're waiting to hear from Tom if they're going to sell the LLC units to the other parties. But at that point, try to just do an agreed order. I can go ahead and file the cross claim. I reserve the right to file with if those people don't want the Bush Jones thing. So we don't keep having to have a lot of hearings when really the only one really involved is the estate. And Tom, so you'll know, I did call. They're only 32 days past due, so they have been paying some payments on the Bush Jones.
Yes, sir. I'll try to work with that. I think a judicial sale is probably the practical way to deal with it. And
if you'll send me an email that they are not going to negotiate with you and there's going to be no more payments, I'll tee it up and we'll send in an order.
Okay, sir. That's good. Judge, it's just one minor thing. It's part of my motion. The K. Bush tax returns need to be prepared. Otherwise, there'll be penalties with regard to that. Jason McKinney is has an unsecured claim. For him to prepare it, he'll require prepayment, $1,600 prepayment for preparing the K. Bush tax returns. And I just did that for the record to make, because I can't unilaterally do that.
Yeah, I don't know that guy, but he sounds pretty savvy if he's asking for that. Asking for that at this stage.
He's bright. He's a very bright fellow.
Yeah. Sounds like he probably knows what he's doing. He probably ought to get paid.
Yes, sir.
Yeah.
Are you talking about payment from the previous year and this year?
I'm talking about for 2020.
Right. Wasn't he also owed for a previous year?
Oh, he's owed. He's not talking about pay. He's not going to get paid out of this for for the past returns. It's for in the 2020 return.
All right.
Yeah, he's just wanting to get paid for what he hadn't done yet. And then he's willing to just go in the mix with everybody else on what he's owed, right?
That's correct.
Yeah.
That's correct, sir.
All right. Well, that's fair. That's more than fair.
Okay.
All right. So, yeah, I don't know if you want to is that in a separate order, or do you want to carve up?
I can put that in a separate order, and I think.
Yeah,
that would
just to
be
keep
okay.
it from being confusing.
Yes.
Yeah.
Yes, sir. I'll do that.
All right, folks. I appreciate it.
Thank you all very much.
Thank you, Judge.
I'm going to move on to my criminal docket.
Thank you.
Let me get,
I've muted. I think
as
it's
these
ready to be
people
shut
are
down.
coming in,
Okay, sound like you
tell them that I'll be right back.
Sure.
If you all will give us just a minute, we're just now switching over from our civil docket.
The ones of you that are on here, Xanda Myers, she's a brand new attorney in our office. Well, she's not a brand new attorney. She transferred here from E-Town, but she's new to Glasgow. So she's going to start with Barron Circuit, and there she is up in the top left on mine. I don't know where she's showing up.
Xanda, you're bottom right on mine. Welcome, and it'll be a pleasure working with you.
Thank you. Look forward to working with you too.
I don't know, Mike Richardson and Risa, doesn't have her camera on now, or the other two attorneys in the office. So if you need anything from us, feel free to reach out and let us know.
Thank you.
This doodad is up to date.
Okay.
I worked on it, so you can see that we're a little full on. We're a little full, like a couple of days in March already.
Uh-huh.
And I've gone through, I can just print them in May and June. I looked those up this morning. I see we're full one day in April already, right? We come back from spring break.
Yeah,
A little congested. There's those.
I understand.
Judge, you may be seeing Xanda Myers' name up there in the attendees. She's a new attorney in our office, so this is her first Monday here.
All right. Good morning.
Morning, Your Honor.
Morning. Our civil docket went way late. We had the K. Bush estate on there. That's the complaint's 375 pages long or something. So we had 30 lawyers, and so anyway, we're in the middle of changing over from the civil disc over to the criminal disc. So it's going to take just a second, and then we'll be ready to get started. Do you all have a plan of attack here about who you want to go first? I know I've got several folks in various facilities around the Commonwealth, probably just one in each one of those, but I might be wrong. Hart County, it looks like what I have. Mr. Brents?
Yes, Your Honor.
Is that the only one I have in Hart?
Yes.
All right, thank you. And then,
Judge, that's my case.
all right.
We're not on yet, are we?
We're not
Okay.
recording yet. We are live streaming on YouTube because that's what the Supreme Court has told us that they want us to do. So fair warning.
Judge, I'm covering Josh's during this morning. He's got to do a Evanston circuit this morning.
Okay.
Judge, I know we got Steve Gensler on from Marshall County, but we'd have to wait for Johnny to get on.
Okay.
Okay, I see Cardell on there. If he's set for a pretrial that Josh has, I don't know who the Commonwealth attorney is on him. But Josh had told me they weren't ready to enter a plea yet on it, that they're still working on the case.
That's my case, Judge, and Josh hasn't communicated with me as far as, that they've agreed to my offer, so that's all I know on the case.
Let me ask Cardell, since he's, and I don't want you to tell me anything, Cardell, about the conversations, but it seems like a couple of weeks ago, the issue was just that he needed to send that information to you and you all needed to have a chance to talk on the phone or whatever. Have we been unable to get all that done, or have you all talked and just don't have an agreement? Which one is it?
We talked before, and then I've been trying to get it to him the past 2 weeks, but ain't nobody messaged back to us. So
Yeah.
I just want to say, the last time we was in court, John, you offered me a year. I'll take the year today and we'll just get on with our day.
Yeah, see, I don't know really what the conversation has been about offers.
Yeah, I can't remember offhand either, Judge. I was trying to look at that. We want to take something up. I can look at this a little bit closer and then, find out if that was the offer I sent out or not.
Yeah, well, I suppose the big question would be, even if you find that out, and it's because Mr. Perry hadn't been dealing with Mr. Kirk, is he going to feel comfortable proceeding with that, or would he want us to move it a week?
Well, we'd have to get the paperwork signed too.
Yeah, if that's the case, it would still take a little bit of time to send the plea documentation to Cardell and get him to sign it and all of that. So, I don't have a problem. Cardell, if your folks that are with you there, if they can tell us that they can do next Monday, I can put you back on for next Monday at the same time, and we can just hope that we get everything done. It's how it works. I mean, the paperwork's got to get signed and all that. And it's one thing if you're sitting here, it's another thing if we've got to send it via email and have you sign it and scan it and send it back and all those things. It just takes a little more time doing it that way.
So,
Can you me going over to next Monday?
if you just send it to our records department, I'm sure it won't be a problem.
What did he say, Cardell? I didn't hear it.
He said if y'all send it to the records department, it won't be a problem.
All right. Well, yeah, we'll go through the same process of sending the link and following up with an email and all that like we do. So as long as you're free to get on another Zoom call next Monday, we'll do that. Okay?
Thank you, Your Honor.
All right. Thank you. Cardell, take care of yourself.
All right, you too.
Will that be at 10, Judge?
Yeah, we'll do that at 10. Do you have his phone? But I guess, Mr. Gardner, if you'll verify whatever the offer is and get that to Josh.
Yeah, I will. I will.
I got the feeling when we talked the last time that it was.
That's my recollection of it as well, Judge. And
I don't know if it's just one that snuck by or what,
I don't know.
All right, so that's 2/1, 10 a.m. All right. Now let us see. Are we ready for Mr. Brents? Who's representing Mr. Brents?
Johnny Bell.
Oh, okay. He's not on yet.
He said it was, excuse me.
What?
He said it was tomorrow. My court date was tomorrow.
Well,
I'll send him a text message now, Judge, and see if he can hop on. If you want me to.
Yeah, please do. What about Mr. Blair in Taylor County?
Yes, Your Honor.
How are you, sir?
Fine, how are you?
Mr. Blair, I believe, is just on for an arraignment
Oh, he is, Judge.
in this 20 CR 267. Mr. Blair,
Yes, sir.
I don't want you to tell me anything about the details of any charges or anything like that, but is this the only case that you have been arrested for, or are you in Taylor County for some other current case?
I'm serving time here.
Are you a state inmate?
Yes, sir.
All right, Mr. Blair, that tells me that I probably need to appoint an attorney for you. Is that correct?
Yes, sir.
All right. Mr. Blair, I will appoint somebody from the Public Defender's Office to represent you. Do you want me to explain your rights to you, or do you waive a formal explanation of those rights?
I waive them.
All right. Mr. Blair, do you, I can tell you that the grand jury in Berrien County meeting on or about 24 September 2020 indicted you on the charges of rape in the 3rd degree and persistent felony offender in the 1st degree. The allegations include that on or about March 23rd, 2020 through and including May 13th, 2020 in Berrien County, Kentucky, the defendant committed the offense of rape in the 3rd degree when he engaged in sexual intercourse with a person who was 16 years old at the time of the sexual intercourse, and the defendant was 10 years or more older than the victim at the time of the sexual intercourse. That constitutes rape in the 3rd degree, which is a Class D felony. The grand jury also alleges that you stand accused of being a persistent felony offender, having been convicted in Monroe Circuit Court in case number 18 CR 088, sentenced to 3 years. In Green Circuit Court, case number 14 CR 035, sentenced to 2 years. And Warren Circuit Court, case number 10 CR 756, sentenced to 3 years. And that you are currently more than 21 years of age, and you were more than 18 years of age when the underlying offense was committed. That constitutes an allegation of persistent felony offender. So, Mr. Blair, I just wanted you to know what you have been charged with. I'm appointing counsel. We are imputing to you, or considering that you are pleading not guilty today, and we will schedule this for a pretrial conference at some point in the relatively near future. Do you have a way to write down or otherwise take down the telephone number for your attorney?
Yes, sir.
All right. Mr. Barry,
It
you
will
want to fire one?
be, it will be Miss Myers that will be representing him.
Okay,
If he's ready, I can give him the telephone number
Yes, sir.
go ahead.
for the office, 833-385-6055.
Did you all get that,
Did
Mr.?
they get that okay?
Did you get that?
Yes, sir.
All right. All right, so let's do this. I'm going to set this for a pretrial conference on, looks like we could do March, let's call it March the 15th.
And Judge, this is my case.
Okay. That'll be at 1 o'clock in the afternoon. Mr. Blair, you've got a number there to call your attorney. Please give them a call at some point. Calling them today won't do much good because everybody will be tied up with Zoom court all day in here with me, but sometime before the next few days, okay?
Yes, sir.
Do you have any questions, sir?
No, sir.
All right. We'll
Thank
see, more than likely on March 15th at 1 o'clock.
All right, thank you.
Thank you.
Judge, just to circle back on that Cardell Kirk, I've checked, and I believe the offer I sent to Josh was a year consecutive to his prior case. So Greg, he should have that offer, and
Okay.
if he doesn't, let me know. I'll send it back to him.
All right.
I just have a strong recollection of our having had that conversation the last time. So my guess, and I'm not picking on him, but my guess is that he just didn't get, the opportunity or get around to getting back with Mr. Kirk. Time has a way of getting away from us, as we know. All right. Let's see. Johnny is on here. We've got Mr. Brent's in Hart County. He's our only person over in Mumfordville, so we were going to try to go ahead and take that one up. He is, I believe, here because the Commonwealth filed a motion to revoke probation.
That's correct. I filed it back in November and the warrant was just served.
Yeah, I was going to say that the warrant was served at some point, but we don't have a return in here, so I don't know when that happened, but obviously it happened. January 20th.
There's a citation in the court record saying when it was served, but
Yeah. It just has not trickled down into the file yet, unless it's someplace that I don't. Yeah, but anyway. Yeah, so Ms. Gardner, what's your request here, to schedule a hearing?
yes.
Mr. Bell, are you hearing me?
Yes, sir. I'm here, Judge.
All right.
I would ask the court, Mr. Brand's had several indictments come down. He has went down to Tennessee and completed a treatment down there since all this stuff has started. He also, I believe it was a heart attack that he had. He had to be taken. He's under a lot of medications and things at this time on that. I don't know if the court, he has never absconded. I know that there was a statement concerning absconded, Judge, but you can't abscond when you let everybody know where he was at. And we done that on almost a weekly basis. And also reported when Mr. Brent's got back from rehab. The only place that he has been is to rehab in Tennessee and completed that, and then to the hospital and for treatment stuff of his heart condition. I don't know if the court would consider reinstating his bond until we could get all this straightened out or not.
Leaving the state and being on probation, they can fine our state whatever they want. You're not supposed to leave the state of Kentucky without, permission, and he didn't get permission.
I mean, there may be a question about who got notified, if any, but his probation officer claims to have not known.
His probation officer, Your Honor, was on every hearing that we had concerning Mr. Brent's. Judge Patton has taken Judge C's place over in Hart County. Judge Patton asked every time if probation and parole had filed any motions concerning him being out of state, and nobody never did. So I don't know if, I'm sure we can split hairs every which way, Judge, but I can assure the court that not only did everybody know where Mr. Brent's was, but we could get recordings to prove that. And not only Judge Patton, but probation and parole also.
Your Honor, I would just say, let's schedule a hearing. I think there's a question whether or not, before the date of November 16th, anyone knew where Mr. Brent's was or could verify whether or not he was in a rehab facility. Whether or not that was resolved after that date, before that time, he failed to report. Those are the allegations. So in addition to 2 felony cases, I would just request we have a hearing.
Yeah. Yeah, I mean, I guess I'm probably at least as concerned about a new trafficking indictment out of Hart County. We can do the hearing. I don't know that we could do it tomorrow because of the probation officer being out of county. Those are harder to track down, and they're not, they don't keep their every other Tuesday afternoons open like ours do. So, I mean, we could try to do it tomorrow, but more than likely it'll be February the 9th.
Judge, I can try while we're here and see if Darlene or Mike, I can contact this officer and see if he would be available tomorrow afternoon.
Okay. You want to do that while Mr. Bell and I and Mr. Richardson move on to our next
Sure.
Marshall County, which is Mr. Ginter. And then we'll circle back to Mr. Brent's and get a firm date. Is it fair, Mr. Bell?
Yes, sir.
All right. So our next case involves Mr. Ginter. Yeah, he's there, Marshall County Detention Center.
Johnny, have you been able to talk to Mr. Ginter about what?
I am not, Your Honor. We had at one time contemplated maybe the feds picking this up. I did talk to Mr. Ginter about that. However, since then, it's my understanding that they're not going to do that. Mr. Richardson made us an offer, I believe, last week. We have had some problems getting a hold of Marshall County Jail. If the court would give us maybe a week or two to get a hold of Mr. Ginter, or maybe ask Mr. Ginter to call collect here at the office. Okay, we'll not go through that way either. I guess we'll just have to try, Judge, to call down there and set up whatever we need to do to talk to Mr. Ginter. I'd like to pass along the offer that Mr. Richardson's made so that Mr. Ginter can make an informed decision as to whether or not he wants to move forward with trial and or accept the offer that Mr. Richardson has given us.
Well, seems like 2 weeks would probably, I don't want to run the risk of giving you too much time and have you wait too long, but 2 weeks would be more likely for it to work than 1 week, don't you think?
I would think that would be correct, Judge.
So the 8th.
That's fine, Judge.
Is there, I'm expecting this to whoever's there in Marshall County working for the jail. Is there any reason that you can think of off the top of your head that Monday, February the 8th at 10 o'clock would be unavailable?
No, that would be available.
All right, super. I mean, we'll follow up obviously with sending you the information and all that, but I just thought maybe you might know of something that right off the bat, it wasn't going to work. So we'll follow up and send you what we do, okay?
Could I ask them, Judge, while they're on, will y'all set up private Zoom meetings between me and Mr. Ginter if we call and get that scheduled?
Yeah, if the phone has failed as forms of communication, yeah, we can do that.
All right. I'll try to get that done then.
Super. All right. We'll move that 2 weeks and we'll be back checking it out. Okay.
Stephen, I'll be hold of you this week. Okay.
Okay.
All right. Thank you.
I believe that's all I have, Judge.
Well, we need to come back to Mr. Brent's.
Yes, sir. I'm sorry.
Just to figure out if we know yet what day. I mean, worst case scenario, if you want me to set it tomorrow, and then if the officer can't be there, we'll just have to do it in 2 weeks.
I'm fine with setting it tomorrow, Judge. We're working on it. I just haven't received an answer back yet, whether or not.
I mean, it was pretty quick. Yeah, it was pretty quick turnaround. Johnny, are you available tomorrow afternoon?
Yes, sir. I'll make myself available.
All right.
Oh, I think we already put it on there anyway. So out of faith.
Well, I tell you. All right, everybody. Let's mute ourselves if we're not talking.
Your call has been forwarded to an automated.
That was Jason. He doesn't know what mute means. All right.
I was trying to call that officer. Sorry about that.
That's all right. That's all right. Hey, we'll see you tomorrow probably on Mr. Brent's, okay?
Yes, sir.
All right, thank you.
Thank you, Judge.
All right, I believe that gets us down to Barron County Detention Center. I've got to figure out what order all this stuff is in.
Judge, I think Mr. Poindexter's here if you want to take his up.
Sure. Let me
Judge,
just,
That was a-
paper.
Judge, that was a case we added this morning, Kara Basil. It had originally been on a couple of weeks ago, but I guess it was continued because she was out of custody. But there's an ongoing case in family court. Mr. Poindexter is wanting to get her arraigned today, if we could.
All right, is she there with you, Mr. Poindexter?
He is, Your Honor.
Okay, fair enough.
We want to go ahead and enter a not guilty plea, waive formal reading of the indictment, reserve any motions, and request a pretrial conference date.
All right. Good deal. Let me just got to move around to where I can find her. All right. All right. This is, your name is Kara Brooke Basil?
Yes.
Ma'am, can you tell me your date of birth?
12192.
Very good. Can you tell me your current address?
Yeah, it's 125 Miller Street, and that's Edmonton, Kentucky.
So you said 125 Miller Street,
Mhm.
Edmonton.
Yes.
Okay, thank you. All right, and Mr. Poindexter, you're indicating to me that you do not, she does not wish to have her rights read or her charges explained. Is that correct?
Correct, Your Honor.
All right, then we will enter a plea of not guilty on Miss Basil's behalf. And like you said, we'll set this case for a pretrial conference. Do you have any particular idea about when you would like to do that?
Like I said, her child custody case hinges on this case, so the sooner the better.
Okay. Let's look at my little sheet here. You know what, I mean, what I don't want to do is just set it at some point where you all don't have any time to do anything with it. But what about February 15th? That'd be 3 weeks.
That should work for me. I've got Warren County Court at 10:30, but I'm figuring it's gonna be video too, so.
Yeah, we would do this at 1. So, you know, that.
Oh, okay.
Yeah, we would do
Yeah,
it
that'd be fine.
in the afternoon.
Okay.
All right. So February 15th at 1. Anything you need to ask the Commonwealth before we knock off here?
No, sir.
Judge, what's the, I don't know what the current conditions are in place as far as the victim in the case is her son. And I think the conditions we're going to agree to are that, you know, normally it's no contact, but we're going to make it to follow whatever the family court rules are. I had talked with the victim's father and I guess another attorney representing the father were kind of telling me about the family court case, and I was agreeable to make it to where she would have to abide by whatever the family court rules are.
Yeah, the condition on her indictment is comply with any order of the family court or the Cabinet for Health and Family Services.
That's good enough.
That's fine.
So, because I think, you know, I can't remember because of how long ago this was, but I'm pretty sure when I saw the indictment, I may have just done a real quick CourtNet on it and saw that there was a family court case. I may have not done that, but since I referenced family court, I may have done that. Or maybe I just assumed that there would be a family court case. But either way, if there's some other entity that's digging in there and monitoring what's going on between her and the children and visitation and any counselings and all that stuff, then I just want her to comply with all that. Okay?
Yes, sir.
All right. We'll see you 3 weeks.
Yes, sir.
All right. Thanks. All right. I believe that's got us down to the folks in Barron County. Bonnie, you're way far away from me. Is that you?
It's me, Judge.
All right. Do you have a Timothy Adams?
I do.
Can we get Timothy Adams?
Good afternoon, Your Honor.
Hello there. This is a what we call, Mr. Adams, an arraignment. An arraignment is when, if you want your rights explained to you, that's when that happens. And if you need your charges explained to you, that is also when that happens. So my question to you first would be, do you want me to explain your rights to you?
No, we don't have to do that.
Okay. My second question would be, do you, I at least need to tell you your charges, so I'll tell you. And then if you want any more information about that, that's fine. If you don't, that is also fine. You've been indicted by a grand jury in Barron County and charged with the following offenses: burglary in the first degree, which is a Class B felony; theft by unlawful taking or disposition under $500, that is a Class A misdemeanor; a second count of burglary in the first degree, that is a Class B felony; a count of theft by unlawful taking of a firearm, that is a Class D felony; and persistent felony offender in the first degree, that is a sentencing enhancement provision that, causes sentences to be greater than they otherwise would be in the absence of persistent felony offender status. Do you need me to explain to you in more detail about those charges, or are you satisfied that you understand what you're charged with?
I understand what I'm charged with. My question is, Thursday when I went to court in front of Pendleton, he's got the same charges on his desk as you do in front of you, and I'm confused on why I got two different bonds on the same case, because I don't have them charges. Also, I don't have them other charges pending. Also, I don't understand it myself, sir.
I mean, I don't know the answer to that. He should not have this case in front of him because you were indicted over 2 months ago. So it should, any case that would have been in district court and would have represented the same charges as this case would have been closed out in favor of this case. So
Judge,
I speculate that you might have another case.
No, I don't. I haven't been in no trouble. I swear I ain't got no other case. It's the same case. It's regularly first degree and theft of a firearm. It's the same thing.
All right.
And it's from July.
Okay, hold on. I don't want you to say anything else that might come back to haunt you. Ms. Gardner.
Judge, I do believe he is correct. And looking at this, my recollection is that the charge, he has co-defendants in this case. This was a direct. And in looking at CourtNet, this 21F, I think 34, which does have the same charges, the citation associated with that just references serving a warrant. It's Detective Bowe is the officer, who's the same officer in this case. So I don't believe there are new charges. He has a preliminary set in that on Thursday, but I can get in touch with Detective Bowe and just confirm that and then speak with Judge Pendleton.
Well, this is probably a conversation for another day, but I'm not sure. This was a direct. So how did it ever turn into a F case? Because it was never an F case to begin with. It was
It's a 21F and the indictment's a 20 CR. So I have no idea how this happened.
Yeah. Well, if he's correct, then, and if you're correct, which you probably both are, since you both think the same thing, then it sounds like you've got a method of correcting that, fixing that.
My other question is, I mean, I know we ain't got to the bond yet. Is there any way with her confirming what I was saying on that? I mean, my bond is at $12,500. My father can't make that kind of bond right now. But with that being said, is there any way that I can get a 10% bond or house arrest on a bracelet? Anything that I can get in order to get out and hire my own attorney and fight it from the streets, because I do have custody of my kid, and I have a job.
Your bond in your district court case is going to be an irrelevancy because that case sounds like it's going to get dismissed. So your bond in this case was $7,500, which represented 2 Class B felonies, a D felony, and persistent felony offender. So if the request is that we did 10% of that bond, then I suppose we put that on the table and see if the Commonwealth wanted to file or wanted to make any sort of response to that.
Or I'm willing to do U-turn, house arrest. I'm willing to do anything I can. But like I said, I got an 8-year-old kid that I have custody of himself, and I have a job. I
understand. I
really appreciate it, man.
Is this your case, Ms. Gardner?
It is, Judge. I just think due to the nature of the charges, this involves K. Bush Estate, and what happened out there, I think that $7,500 cash is an appropriate bond. He's facing some serious felonies. He is a convicted felon, so this isn't his first time before the court.
I've been in trouble in 8 years, man. Please. Anything where I can get out. $7,500 is a lot of money, right? But man, my dad can't afford that right now. Anything. Any kind of 50% or anything. Just something other. Anything other than $7,500, please. Or house arrest. I'll even do the house arrest and pay for it or whatever. I've got a lot going for me, and I've got custody of my own kid, and I don't want to lose my kid and my farm and everything else I got going for me.
I understand. Here's what we're going to do. First off, we kind of got the cart in front of the horse there. I'm going to enter a not guilty plea, Mr. Adams, on your behalf, and we'll set this for a pretrial conference on, I don't know. There's some co-defendants. I don't know when we've got them set. Probably unreasonable. They're probably not all set at the same time because some are in and some are out. Let's just say February 22nd at 1 o'clock. Now, listen, as far as your bond is concerned,
please,
I will just quit talking for a minute. I'll agree to a 10% bond on the condition that you are monitored through U-turn with I don't think house arrest is necessary, but a curfew with an ankle monitor.
So does that mean I'll be able to work also?
Work will be allowed.
Okay, thank you.
I will, normally, we do a curfew of, something like 8 p.m. to 6 a.m. If your work conflicts with that, you can work that out with her. And as long as she gets proof, as long as they get proof of when you're working and that you're going straight to and from and that kind of thing, that's not a problem. All right.
My next question.
Hold on. There's going to be no drugs, alcohol, maybe random drug screens. Make all court appearances. Meet with your attorney. Okay.
Okay. And so now will the downstairs thing hold me over, or is that going to be dismissed now that?
I think they're taking care of that.
I just talked to Detective Bowe, and this is the only case that he has. So that's an error, and I'll contact Catherine about it.
I think they're taking care of it.
Thank
All
you.
right.
Judge Ms. Myers will be representing him. I don't know if he mentioned he may hire somebody if he gets out. That's fine, but she will be
let's give him a phone number. And if he gets out and he goes to hire an attorney, then I want him to call your office first thing and let your office know that he has hired private counsel. But if not, I want him to make a phone call and set up a meeting to talk to his attorney that I have appointed for him. So, and that needs to be done before we come back. So you want to, Bonnie, you know the number, or do we need to give it to you?
I got it, Judge.
All right. So
Judge, could I ask that he give Bonnie his phone number and an email address?
Yes, sir.
Okay.
Yeah. Super.
Is my bond $750 in? Is that right?
Yes.
Yeah. Plus that other stuff.
Okay. Thank you.
All right.
Thank you.
You bet. I have a line through Amber Carver, but are we? I think we're actually doing Amber Carver. Eric Denton? Huh? Oh, he's on, he may be on for 2-1. Nobody's ever told me anything about him. Bonnie, do you have Amber Carver?
I do not, they said to take her off.
Okay. Do you have Brooklyn Flickner?
I do.
Let's do that one next. They told me to put her back on, but I guess they didn't. It's not gonna matter. All right, Ms. Flickner, our purpose for being here today, I believe, is because there was a probation violation turned in from probation and parole back on or about January the 14th, maybe. The probation and parole requested that a warrant be issued, which occurred. I do not have a motion from the Commonwealth unless you all have filed it and it hadn't made it into the file, but.
Your Honor, Darlene has been out of the office for a little bit. She had an exposure to COVID, and so that we might be a little bit behind on doing that. We intend to file a motion.
Okay. The allegation by the, since you might not have it, is, let's see, there was positive drug screen, failure to attend counseling, and failure to report. So those are all sufficient, I think, for me, based upon Officer Alexander's report, to find probable cause that there has been one or more probation violations. And we will set this for a hearing on February the 9th.
What was that day, Judge? I couldn't.
February 9th.
Okay. Okay.
That'll be at 1:30, and the Commonwealth will file a motion prior to that day and serve notice on the DPA.
I'll resend it in case somebody didn't get it, but I sent it out on the date that I did the report.
And Jason, it's probably in Darlene's inbox, but like I said, she just came back into the office today, so.
Okay. Well, if you need anything from me, just let me know, and I'll be glad to send you what I can.
Will do.
Yeah. Just some salient points of interest are that her convictions were both for possession of a controlled substance, both amended down from trafficking in a controlled substance, and that she is on pretrial diversion at this point in time. So I'm just throwing those are things that everybody usually needs to know, and I'm just telling everybody so you don't have to find them out yourself. All right.
And Jason, has she been sent to have an assessment since she's been picked up, or?
What, that's, no, she's not. I was gonna wait and see what y'all want to do. I can put her on the list, but the problem was she wasn't showing up for what she was ordered to do by the social service clinician. But if you would like one scheduled, I'll be glad to do that.
Yeah, just go ahead and do that so we've got that in hand.
Yeah, that was an attempt, I think, at outpatient.
Yes, sir.
That was one of the things that was in his report.
Okay. Yes, sir. I'll be glad to do that.
Ms. Flickner, we'll be seeing you. It'll be 2 weeks.
Okay, so I'm sitting for 2 weeks, just sitting here. There's no way to get house arrest or anything because I'm fighting a family court case, and I'm really trying to do what's right. I know I wasn't, but I mean I really am. I was gonna ask for IOP, like to where I could be drug tested once a week and do the 2-hour counseling, but I know it's probably out of the question. I have a family court case coming up, and I've done missed my daughter's first birthday, so it's kind of like
Brooklyn. Hey, Brooklyn, your family said you weren't taking care of your children anyways, and you were living in a floor of a shop because you wouldn't.
Hey, wait, hold the phone. I've already said that there's probable cause that there's been a violation or more of your probation. I'm going to hold you in custody till we can have your hearing, and your hearing will be in 2 weeks. Okay? All right. Timothy Miller.
Hello, Your Honor.
Hello, Mr. Miller. This is, excuse me, this is an arraignment. Mr. Miller, do you wish for me to explain your rights to you?
No, sir, it's not necessary.
All right. Do you wish, well, let me back up. You are here today based upon an indictment from the Barron County Grand Jury, which was issued back on 24 September 2020. In that indictment, the grand jury alleges that you have committed the following offenses: trafficking in a controlled substance, first degree, 2 grams or more. Second offense, that is a Class B felony. The allegation is that on or about July 29th, 2020 in Barron County, the defendant knowingly and unlawfully possessed 2 or more grams of methamphetamine with the intent to sell, distribute, dispense, or transfer it, having previously been convicted for trafficking in a controlled substance. The grand jury goes on to allege that you have committed the offense of trafficking in synthetic drugs, with the underlying facts being that on July 29th, 2020 in Barron County, the defendant knowingly and unlawfully trafficked in synthetic drugs. The grand jury also alleges that you committed the offense of tampering with physical evidence when on July 20th, 2020 in Barron County, Kentucky, you destroyed, concealed, removed, or altered physical evidence which you believed could be produced or used in an official proceeding that was then pending or that you believed was going to be instituted against you, and the intent was to impair the availability of the evidence in the official proceeding. The grand jury also alleges that at that same time and place, you committed the offense of possession of drug paraphernalia when you used or possessed with the intent to use drug paraphernalia. The grand jury also alleges that at that same time and place, you committed the offense of possession of marijuana when you knowingly and unlawfully possessed marijuana. Finally, the grand jury alleges that you are a persistent felony offender based upon the following allegations. You are over 21 years of age. You were more than 18 years of age when the underlying offense or offenses were committed. And you have been charged, convicted of felonies as follows: 18 CR 528, Barron County, Kentucky, possession of a controlled substance, etc., and sentenced to 1 year in the penitentiary. Barron Circuit Court 14 CR 143, complicity to trafficking in a controlled substance, first degree, sentenced to 3 years in the penitentiary. Barron Circuit Court 10 CR 76, possession of drug paraphernalia, second offense, which was a felony back in those days, and sentenced to 2 years in the penitentiary, all of which taken together constitutes an allegation that you are a persistent felony offender. Mr. Miller, do you understand what all it is you've been charged with?
Yes, sir, I do understand.
I'm going to appoint counsel for you, and impute a not guilty plea on you here, or for you here today.
That will be Miss Myers, Your Honor. Well, I'm assuming we're appointed, so.
Yeah.
Okay.
Yeah. And Mr. Barry will need, or Miss Myers, if you're still with us, we'll need to set this for a pretrial conference. That's probably going to need to be set on February the 22nd. At 1 o'clock. Mr. Miller, the original issue here was that Mr. Miller was originally left, attempted to leave him out on bond pending an arraignment. He was out on bond in district court. He was reporting to U-turn periodically back during the summertime, at least. I think there ended up being an issue with reporting. Mr. Miller was picked up by the authorities on a new charge. And at that time, they brought him to the U-turn program. And according to Julie, he tested positive for methamphetamine and amphetamine, MDMA, and marijuana. That, is contrary to the bond conditions. And I believe that what would be appropriate for us to do would be at the very least to, I'm not going to revoke Mr. Miller's bond that he was out on, but I'm going to change it from a summons to a bond commensurate with a Class B felony trafficking charge of $5,000. And if he does not make that bond, Mr. Barry or Miss Myers, then we will see him on February 22nd at 1 o'clock. And we, if you all, that gives you all the opportunity to at least discuss this case and whether or not there's anything that can be done within 4 weeks, Okay.
Your Honor, the Commonwealth had filed a motion to revoke his bond in this case. We'll withdraw that motion because you modified his bond at this point, so.
Okay. Yeah, and I apologize. I didn't see that motion because it was underneath his, the citation returning his arrest warrant. If you all would rather me schedule it for a hearing on that, but I figured this was just about the same.
Right, that is fine.
All right. So we will see you on, more than likely, on February 22nd, Mr. Miller.
I won't be able to make a 5,000 cash bond, so. That's what it is, 5,000 cash bond right now?
That is correct for now. Yes, sir.
Okay.
Yes, Turner.
Mr. Turner's my client, Judge.
Sir.
All right. This is before the court on the Commonwealth's motion to revoke bond. The last, let's see, the last thing I had in the file before that motion was where Mr. Turner made bond back around the beginning of the year. And it looks like the Commonwealth's motion is based upon a new felony arrest. Is that right, Mr. Richardson?
Yes, sir, that's right.
Was that arrest in Berrien County or Monroe County?
Berrien County, Judge. It was an arrest for failing to update his address while he was out on bond.
All right, yeah, it looks like the charge was failure to comply with the registry.
Yes, sir.
Does Mr. Barry?
Is this case yours, Mr. Barry?
It is, Judge.
All right.
Mr. Barry, have you showed him my paper yet? Well, I was ordered to be removed off of that.
No, Jesse.
Well, you need to get, I mean, we need to get all this down here, man. I mean, because this is just going in circles. I mean, I was ordered to be removed off of there. I failed to make one phone call. Now I'll get my bond revoked. This is nonsense, Barry.
Well, hang on, Jesse. There was another order after that one putting you back on the registry. So,
Oh, it wasn't neither. I got both orders. My family's got them. Both orders. One came in. It said was denied by the Kentucky State Police.
okay. Well, tell them to bring.
Judge John C. ordered that. He said, no, they cannot try to put me back on there.
Tell him to get that information to Mr. Berry then, because I mean, there isn't any way he's gonna know about that unless somebody brings it to him.
Well, he's got all of it.
No, I don't. But whatever.
He says that he does not.
Judge Detective Bo called probation and parole before they made the arrest, so.
Yeah, I don't have anything in here about the arrest itself, so
We could set a hearing.
I'm sure that's easy enough to get. We'll put it on for a hearing on 2/9, 1:30. All right. All right, Mr. Turner, thank you.
All right.
Dion Wagner.
Hello, sir. How you doing?
Hello, Mr. Wagner. Mr. Wagner is here for, I believe, 6 different cases. That case and this case, which are 13 CR 225 and 14 CR 142, are cases for failure to pay restitution or appear. The other cases are pending cases that are failure to appear for pretrial conference.
Can I elaborate on those, please?
Sure.
For my 13 and 14 CR cases, my restitution cases, I was paying restitution up until like, I want to say maybe December or the end of November. I had made payments on those. And then I had caught Corona. Let me see. I've got my papers and everything, like all my documentation with me. I had caught Corona on one of those days, and that's the reason why I didn't go to court. I missed the court date. Here's my paper right here. I went to the doctor. If you need to see that paper or not, I don't know. But on the 12th, says 10/12/2020, I had a court date on that date. I had an appointment or whatever for the doctor, and then I've got my Corona test where it come back positive or whatever. And then I've emailed my lawyer and stuff, and I talked to him where my employer sent like, you know, a paper stating where I had to quarantine for a few weeks or whatever. Like, I've got all my documentation here. I sent that to my lawyer. And like, basically, my grandmother's sick. She just now like lost a toe maybe 2 weeks ago, and she's in the process of losing another one. I haven't like just been screwing off or not doing it like what I'm not supposed to be doing. Like, I've basically just life's just been hit me all at once. I had to take care of my grandmother, and it is my fault that I didn't make it there. So I'm not blaming nobody else or making excuses or any of that for anything that's been done. I just telling you, you know, I'm gonna take responsibility for not being there because that's what it is. But I haven't been just screwing off and not, you know what I mean, not coming on purpose or getting high or anything like that. Like, I've literally been trying to take care of my grandmother. And like, I have all the paperwork and documentation for anything that you want to know, like as far as me catching the Corona and stuff.
Well, that'd be good to get to your attorney, because on June 8th, your attorney told us that you couldn't be here because you had the coronavirus you had reported to him. So we moved it to June 29th. On June 29th, I think maybe you were here.
Yeah, I did. Okay.
We set it for August 31st. On August 31st, your attorney said that he had gotten a report from you that you were quarantined. So we moved it to September 14th.
Yes, sir.
September 14th, your attorney said he got a call from you that you were quarantined. So we moved it to September 28th. On September 28th, your attorney said he got a call from you that you were quarantined, and we moved it to October 12th. On October 12th, you did not appear or call him and tell him that you were quarantined. So I mean,
Here's my doctor's. I've got the email where I sent him. I just spoke to him on the phone. Here's my doctor's statement on the 12th, where I actually went to the doctor, and then where I had the corona. I've got that paper on that date too. So I have all the.
Governor, if I may interject, I don't think any of the communications that I think Tyler was representing at that time were from Mr. Wagner. I think they were all from Mr. Wagner's alleged employer. I don't know if he had.
Oh, it was for me because my employer wrote my paper for me, and I had to email Tyler Scott. And I've even got like the conversations between me and Tyler.
All right, hey, let's quit talking, because what we were being told when we came to court was that your boss was telling him that you were quarantined, and we told him that he had to get something from you, you know, and that you either had to show up here in person or produce proof, you know, that came from you that you were medically unable to be here. And on October the 12th, that day came and that day went, and we didn't have either your face or any proof from you that you have been quarantined.
I emailed him, sir.
I'm just telling you what I know, not what, you know, I don't know what you know. That's why we have hearings, to decide, you know, there very well could be something that I don't know, and we'll find out, but we're going to have a hearing to do it. Because, and you did make some payments on your restitution. You weren't paying every month, but you made a few payments over the course of the spring and summer, it looks like. So, you know, maybe we'll have to dig around and look and see how much you paid and whether that's going to be acceptable or not. The last thing is that we have this new indictment, which is 20 CR 382, which came down on, it looks like, came down in November, that we have not arraigned you on yet, which is theft of identity of another, possession of a controlled substance, fleeing or evading second degree, resisting, menacing, and persistent felony offender. So I'm going to have to arraign you on those charges, Mr. Wagner. So the first thing I'm going to do is tell you your rights. You have the right to remain silent. You do not have to say anything that can be used to prove these charges against you. You have the right to an attorney, and one will be appointed to represent you. You have the right to a trial by jury, where the Commonwealth would have to have the burden of proving guilt beyond a reasonable doubt. You have the right to have the assistance of your attorney in confronting and cross-examining anybody that gives evidence against you at trial. You have the right to put evidence on in your own defense at trial, and you have the right to appeal the outcome of your case to a higher court. Do you understand those rights?
Yes, sir, I do.
All right. Pursuant to the grand jury indictment, you have been charged as follows. Count one, on or about November 26, 2019, in Barron County, the defendant committed the crime of theft of identity of another without consent when he knowingly possessed or used current or former identifying information of another person with the intent to represent that he was the other person for the purpose of avoiding detection. That theft of identity is a Class D felony. Count two, on or about November 26, 2019, in Barron County, the defendant committed the offense of possession of a controlled substance, first degree, first offense, when he knowingly and unlawfully possessed methamphetamine, a Schedule II controlled substance. That is a Class D felony. Count three, on November 26, 2019, in Barron County, the defendant committed the offense of fleeing or evading on foot, second degree, when as a pedestrian with the intent to elude or flee, he knowingly or wantonly disobeyed a direction to stop given by a peace officer who had a reasonable suspicion that a crime had been committed. And while so doing, the defendant was the cause of or created a substantial risk of physical injury to any other person. You are also charged with resisting arrest. The grand jury states that on November 26, 2019 in Berrien County, you intentionally prevented or attempted to prevent a peace officer from arresting you by using force or threatening to use force against the peace officer. Count 5, the grand jury charges that on November 26, 2019 in Berrien County, you committed the offense of menacing when you intentionally placed another person in reasonable apprehension of imminent physical injury. And count 6, persistent felony offender, the grand jury charges that you are more than 21 years of age, you were more than 18 years of age when the underlying offense was committed, and you have been previously convicted in Berrien Circuit Court, case number 14 CR 142, of trafficking in a controlled substance, first degree, 5 counts, and sentenced to 3 years in the penitentiary, and that you've previously been convicted in Berrien Circuit Court, indictment 13 CR 225, wanton endangerment, first degree, criminal mischief, first degree, both of which are Class D felonies, and sentenced to 3 years in the penitentiary. Mr. Wagner, do you understand what you have been charged with in this new indictment?
Yes, sir, I do.
All right. I'm going to appoint counsel from the Public Defender's Office to represent you. You're already being represented in 1, 2, 3 of these other cases.
That's a question about that. I have a stimulus, I have my stimulus payment waiting on me as soon as I can get out to cash it. Is there any way that because I promise you, my grandmother's sick, y'all can call her right now. Can I get back out on ankle monitor? Last time I asked for ankle monitor, my resources and stuff wasn't to where I could absolutely get it right then and there. But if I could get ankle monitor to be right there at my grandmother's, I can get out today and make that today where y'all know exactly where I'm at. And it give me time, and I'll get another attorney to represent me for this because I have a $600 check. I just like to get it cash. If you can please let me out on ankle monitor so I can be there for my grandmother. I don't know how much longer she's gonna be here. Please.
Your Honor, I mean, this is just a continuing saga with Dion. I mean, we're trying to get all of these cases, resolved in some fashion. It just never seems to happen if he's out.
I have complied with most of the stuff though. I mean, I've even been paying child support and everything. You can look up my records. I've been doing what I'm supposed to be doing, just this last little bit. I mean, due to this corona and stuff, it knocked everything out. It ain't like I haven't, I just went, MIA and nobody knew exactly where I was at or anything. Just please let me out so I could be there with my grandmother. I'm her primary caregiver and stuff. I've stayed there with her. Y'all know exactly where I'm at. And I mean, if I'm not there, then.
All right. Hey, listen, I do not want you to miss out on a time with your grandmother, Mr. Wagner. However, I also want there to be some, however brief, uninterrupted stretch of you showing up in court when you're supposed to and doing what you're supposed to do. And you've promised me that until I am blue in the face, and it has not ever happened. And these are hard times for everybody. And I hate it that people are old and people are sick and that people might be missing out on it. But I can't let what the right thing is to do. I can't let emotions overtake that. I mean, there's no way in the world that at this point in time, given your track record, that I can trust you to do what you're supposed to be doing.
I have on my papers.
You can tell me all that you want to, but you're not going to sell me on it right now.
Please, sir, please.
I'm not going to. I will see you on February the 9th.
All right.
All right. Thank you.
Judge, Ms. Myers will be representing Dion also.
All right. Fair enough.
Has he got 3 cases still pending before this latest indictment?
Yeah, he's got the 2 restitutions, which are over. He had 3 pending and now this new one. So he's got 4 pending.
Josh took those cases over from Tyler.
Oh, okay.
He has those.
All right. Never mind. Josh can take the new one then also.
Okay. Yeah, he won't mind. All right. Do we see anything else on our docket like PTDs or anything? I believe that's the jail.
Judge Estill Cunningham was on. I think he's in Kenton County.
Yeah, I don't know a thing about Estill Cunningham. I didn't know where he was. I just knew he wasn't in our jail. I don't have any idea where he is.
I just looked on Cool and that said where he was
Yeah.
being housed was Kenton County.
I mean, I don't know why, I don't know what happened, but apparently nobody told Kenton County because they're not on here. All right, Bonnie, is that everybody down there for now?
I've got Vicky Wilbur.
Yeah, is she a Metcalfe County case?
No, Barron.
Oh, okay. Well, I put her on my list.
She's on for
All
the
right.
arraignment, Judge.
Yeah, we'll do that one. All right, hold the phone here for just a minute. Gotcha. Okay, Ms. Wilburn, you are here because you have been indicted grand jury in Barron County of possession of a controlled substance, first degree. That's a Class D felony. Possession of drug paraphernalia. That's a Class A misdemeanor. Do I need to explain your rights to you?
No.
All right. The allegations are that on February 14th, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine, a Schedule II controlled substance, and that you knowingly used or possessed with the intent to use drug paraphernalia. Do you understand your charges?
Yes, Judge.
All right, ma'am. Ms. Wilburn, am I going to need to appoint counsel for you?
Yes, Judge.
Okay. So I'll take care of that. We'll enter a not guilty plea on your behalf here today. We'll set this for a pretrial conference on, shouldn't take all that long, February the 15th. All right. Did you have 2 warrants served on you or just one?
Just one.
Okay. So do you just have one case that you're aware of?
Yes, Judge.
All right. Ms. Wilburn, the biggest problem here, you know, I got information from U-Turn. That's why this ended up turning into a warrant. None of that's made it into your file yet, but going by memory, I believe the issue was that they were trying, you had a bond condition to get random drug screens and you were not getting those random drug screens. They were calling you and you weren't showing up. There may have even been a dirty one in there somewhere, but I can't remember. But here's the deal. I'm going to give you a chance to get that straightened back out. So I'm going to reinstate your bond. You need to report to U-Turn by the end of the day and get that set back up and be on random drug screens between now and whenever I see you again. I tell you what, it's not gonna, let me back up. February 15th is a bad day because it doesn't make any sense if she's getting out. We'll make it March 15th.
Okay, yes, Judge.
1 o'clock. All right. And a condition of your bond, as I said, is that you report to U-Turn random drug screens if they call you. Obviously, no drugs and alcohol. Make all your court dates and contact your attorney. Make sure your attorney knows how to get in touch with you when and if something may change. We're in a time where these court dates change because the courthouse has to be closed and all that. And, you know, your attorney needs to be able to reach out to you and tell you, okay?
Yes, Judge, thank you.
What is your address, if you don't mind my asking?
It's 404 Rogers Street, Edmonton, Kentucky.
Judge, could I ask her to give her phone number and email address to Bonnie?
Yeah, Ms. Wilburn, give Bonnie any information contact information that you have, cell phone or email if you have one, that kind of thing, okay?
Thank you, Judge.
All right, very good. Thank you.
Thank you.
Is that it, Bonnie?
All of that, Judge.
Judge, can I say one more thing, please, before you cut off, please?
What?
Listen, there comes a time and point in everybody's life and stuff that I know that you gotta own up to your own responsibility. And listen, like, I promise, like, my grandmother, I don't know, she's day to day. Please, can I get out on ankle monitor? Like, if I don't comply with everything, like, I'll plead guilty and y'all can sentence me to whatever. But like, I don't want to be in here and my grandmother passed away. Like, please give me like the ankle monitor where y'all know where I'm at, and I'll comply with anything that y'all need me to do. And if I don't comply with it, then y'all can make me sit in here and write, please. Please.
I don't want you to be in there if anything happens to your grandmother, but I mean, I'm not the one that got yourself put in there.
And I understand it too. So
I can't let people,
please,
I can't treat one guy different because his grandmother's sick than I do somebody else, you know?
I have all my papers and stuff stating where, and I emailed my lawyer, like, please give me another chance, sir, to be out there with her, please, sir, please. Like, I don't want to keep, bugging you on stuff, but please, like, I've did a lot of, like, taking care of her and stuff. And then
I understand.
That I'm in
Listen,
here, man.
I'm not changing my mind, okay?
Yes, sir.
All right, thank you.
What about Dylan Loyal? Have we done anything on that?
No, what I'm trying to do is let these poor people at the jail go, and then we'll deal with anything else we got. That's it, Bonnie.
That's all of that, Judge. Thank you.
All right, thank you.
See you this afternoon.
You betcha. All right, the Dylan Loyal is just a pretrial diversion review.
Okay.
We're okay with that dismiss, Judge.
All right, thank you.
Yeah, it looks like he, good Lord, the last thing that was in here was a warrant. And I thought, oh my gosh.
I don't have anything recent that I know of.
Yeah, there was an order after that warrant. They just were out of order. So he did a sanction and got in and got out, and he's done. All right, so we'll dismiss that one. I believe that's all I have.
Judge, I spoke with Officer Embry in the Ronald Brent's case, and I've spoke with Johnny. We have a resolution just to do a time served contempt. So we don't need to have a hearing. Would you like an agreed order, or is that something you can do a calendar order on? How would you like us to?
I think if we're not going to be doing it on the record, I'd prefer it if you all just circulated an order and send it, uploaded it where I could actually sign off on something.
Okay, I'll get it together.
Is he gonna be getting out today?
I'm fine with that.
All right. All
So
right.
I'll try to get something done and get Johnny to sign it and send it your way.
If you
Hey,
feel comfortable enough about it, I can go ahead and send the commitment order over there to him, allowing him to be released back
That's
on.
fine with me.
Okay.
Can you mind, Your Honor, putting my name to his report to me by telephone, and I don't know if he has my number. Is it all right to put my number on that order saying to call this number when he gets out?
Yeah, why would he report to you and not to officer in Hart County?
Cause he's still on they sent him back to my caseload because he absconded.
That's weird.
Yeah. When they abscond, they send it back to the county they came from.
All right, well, tell us the number you want him to call and I'll have Jennifer put it on there.
Okay, it's 270-779-3589. And then I'll transfer him back over there.
All right, so we'll tell him that he needs to call you at that number immediately upon release.
Yes, sir. Thank you.
All right, thank you. See you at 1:30. Your guess is as good as mine how it's going to work out with Barron District. But I guess we shall see. We don't have a huge